before the police station at Bondo by summons and accompanied by counsel, that is Mr. Musongo, and that the respondents are prominent people in the society. The first respondent being the Chancellor of JUST, the second respondent is a regional coordinator of BMU, CI County, and the third respondent a teacher at Sh200k High School, and informed court that the persons are not likely to fail or attend court when ordered so. Further counsel submitted that the respondents have health conditions and the continued detention of the detrimental to the safe respondents, and urged the court that the respondents are innocent until proven guilty. The counsel urged the court to admit the respondents to reasonable bail and bond and set a date for the respondents to appear before the High Court for plea-taking and directions. In a rejoinder, the prosecution through its counsel submitted that the issue of destruction has the charges already approved, and that their affidavit isn't mere allegations, and the evidence shall be tabled during the matter trial before the High Court. She submitted that the prosecution is in the process of processing witnesses for women's protection and urged the court to allow the application as paid. The court reserved a ruling for 2 p.m. today, and on analysis, what is before court is an application seeking the court to allow continued detention of the respondents, that is the first, second, and the third respondents, to assist in the investigation that they be taken for a mental assessment before being produced before the High Court for plea-taking. I know that the prosecution has indicated to this court that the charges for murder against the respondents have already been approved by a letter reference number ODP/ADV/25/277, and that the mental assessment has not been conducted as the psychiatrist at Siaya County Department Hospital is currently on festive season leave till the 7th of January 2026. I know that what the prosecution is trying to tell the court is for them to be allowed to obtain the respondents pending the availability of the state psychiatrist. The charges have already been approved, and what a prudent investigating officer, the IO, was to do is to draft a charge sheet and present the file before the High Court for directions of plea-taking and fitness to plea by the said respondents. What the prosecution is trying to seek are orders which are in the purview of this instant court, the magistrate's court. The investigation officer has the liberty to engage a present or a working psychiatrist from another facility and not necessarily CI County Department Hospital and present the respondents before the High Court for plea directions. On the issue of threats of witnesses, I know that the prosecution has mentioned 3 OB numbers. That is OB 71/19/12/2025 at 17:20 hours, OB 81/19/12/2025 at 18:32 hours, and OB 7/23/12/2025 at 06:38 hours. I note that none of the said copies of the OB extracts have been attached or to allow the correlation with the respondents before the court. That is the first, the second, and the third respondents. I'm unable to deduce to what OBs mentioned relate to and to what nature of the offences. The prosecution has also submitted that meeting the respondents to bail and bond would not have in the best interest, and that a pre-bail report be done and filed before this court. I note that Article 49 of the Constitution contemplates the rights of the arrested person to be released on bond and bail on reasonable conditions pending the charge or trial unless there are compelling reasons to be released. So I will not majorly go into the Article 149, which is within the knowledge of counsels. So the right to bail and bond is not absolute. The courts have to weigh the arrested person's right to bail and bond against the position of bail and bond by the state. So I have attached a few cases there, which are due to time, but not go into them. So Section 123A of the Criminal Procedure Code and the bail and bond policy guidelines further require the courts to weigh the different factors, including the seriousness of the offence, that is, or rather the charge, safety of the accused, and likelihood of the interference with witnesses. Looking into the reasons tendered by the prosecution seeking detention of the respondents for 14 days to assist in the investigation, there is a clear indication that the charges have already been completed and approved as per the letter attached. The question at hand is why did the investigating officer fail to do charges and have the respondents arraigned before the High Court for plea directions? I find that the application by the prosecution before this court is not merited. However, in the interest of justice, noting the respondents are persons well known in the society with no drug cases and even presented themselves to board administration upon being summoned, and are likely to abide as per the directives of this board of opinion. So I have come to the conclusion that the prosecution has not established the existence of compelling reasons that mitigate against the release of the first, the second, and the third respondents on reasonable bail and bond terms pending the finalization of the preliminary requirements before the respondents are arraigned before the High Court for plea-taking directions. So I make the following orders. First, that each of the respondents, that is the first, the second, and the third respondents are each admitted on a bond of penalties 200,000 plus one surety of a similar amount with alternative cash bail of 100,000. So once released, that is the second conditions. Once released, the respondent shall not be in contact with the prosecution witnesses, interfere with them, or in any way directly or indirectly. Third, that is the first, the second, and the third respondent shall attend to this court and the investigation officer as to when required and needed. So fourth, failure to comply with any of the above conditions shall lead to cancellation of the bond and bail without further reference to this court. So I'll issue a further mention date for the elections, which shall be on the 12th of January 2026.